payroll versus service?
I think she's having difficulty hearing you. Sorry.
Are we breaking even providing service to that territory, to that district?
I think it would be a correct statement to say that the direct operating costs of service are being offset essentially by payroll tax revenues.
And fair.
Fully offset. Yes, including fares.
So I understand that we recently added trips that you alluded to enhance the service. Prior to that, was there ever a greater level of service offered in this area, and was it diminished? Has it diminished over time, or what's the history?
I think generally in the history, the level of service has been pretty consistent over time. The only modification to service in recent times was a routing change that we made at the time of the withdrawal of the city of Sandy in 2001, so that the routing of the line was modified at that time. But the schedule has, up until September, I think, has been consistent.
And relative to our, let's say, our average performance, these numbers are extraordinarily low in terms of boarding and annual trips and that sort of thing for a bus line or a share bus line, right?
Yes, I would say that, that's absolutely right.
Correct.
One additional question. Is there any understanding from those that participated in the survey and said that they utilized MAX? Could we understand whether or not they utilized it as an occasional opportunity to get around the region versus a means of travel on a regular basis where they may drive to a park and ride lot in Gresham and then use it to go into Portland for their employment or their cultural experiences on a regular basis, or is it just sort of a situational once a year, twice a year use of MAX?
Well, there are a couple of questions that would shed some light on that. We asked people generally how often they were riding, among those who said they rode. And among the respondents in the area, about 5% of folks would be classified as frequent or regular riders of TriMet, and that would be almost every day or several times a week. The others would be occasional and infrequent. The comparable numbers for the district as a whole are about 20% in the regular frequent category. And then when we asked folks where they were traveling to, among those responding, about 90% indicated generally traveling to Portland, with about the majority of those being downtown Portland, and the others indicating other destinations within Portland. A smaller subset said they were traveling to locations in Gresham. So that's the location piece that we know about.
Just so that I make sure that I have it correct, we're actually transporting more lift clients than we are fixed service bus riders on an annual basis. Is that
would be correct, yes. The total number of lift trips being provided does exceed the number of fixed route boardings in the area by roughly a factor of 5.
Mr. Chairman, a question on that. Would I be safe to assume, under the current uses when we talk about the lift services, that the one-way trips, is there any data that gives us, or can I double this to get to a safe round trip, or that would not necessarily be the same?
It's simply a notation that indicates what the number represents. In the case of Lyft, most of these trips are made are round trips. So if you actually would be dividing the one-way trip number by 2 to estimate the number of round trips that are represented. The one-way trip number divided by 2 would give you the round trip activity. But I've also reported fixed route ridership numbers that I've reported are also one-way trip basis numbers. So just reporting each trip as a unique event in those counts.
Okay. Thank you very much.
With that, then maybe you could ask Ms. Tran to review the findings and conclusions and recommendations of the hearings officer as well as procedural next steps.
Thank you. I will do that. I will start by just talking to you about the procedure. We've had the opportunity to discuss the procedure at the retreat. I gave you a handout. I have that handout for you again if you are at all interested in it. But we are quite a ways through the process. I think you may recall that this is a procedure that can only occur every 5 years, and that a petition must be filed between January 1 and August 30th of the year in which it is allowed. The petition here, of course, meets that requirement. It also has to have not less than 15% of the electors in the area, in the affected area. It met that condition too. It was certified by the county clerk, Clackamas County Clerk. So the petition is properly in process right now. We held a hearing on November 3rd, as you just heard about. Sid Broccoli was appointed by this board to consider evidence and reach findings, facts, and conclusions of law. Before I get there, let me sketch the law a little bit for you. You recall that there are two types of withdrawal that can occur. There's a mandatory withdrawal if the statutory criteria is met, and then there is a permissive withdrawal if it is not. In this case, the petition does not meet the requirements for mandatory withdrawal, and that is simply because there's direct service in the area. So that leaves for you to consider what is in the best interest of the district and the affected area. And that is, in fact, what the hearings officer was doing. So at the hearing, the hearings officer received exhibits. They are all officially marked as part of the record. There is a potential here for a court review of your decision. You are sitting as a judge would sit on a matter. As you've heard, this is the quasi-judicial matter. And so the petition is received as an exhibit. There were a number of what we call advanced comments that were received. There were people who testified live at the hearing. It's not a weighing of the evidence. It's not a question of were there more people there in support or against the petition. It really is a matter for you to look at the quality of the evidence and to look at the record as a whole. When the court looks at your decision, it's going to be tested by the standard of substantial evidence. And what that really means is what I just said, looking at the record as a whole, could a reasonable person have made the decision that you make? So in looking at the hearings officer's report, the hearings officer concluded that it would not be in the best interest of the affected area or the district to allow withdrawal. Now, you are not bound by that decision. That is one factor that you can consider. What seems to have been persuasive to the hearings officer was the fact that there were a number of Lyft users in the area and a number of elderly people in the area. And there were received by the hearings officer were some reports, letters rather, one from Clackamas County, one from Sandy, that talked about how the need would be filled. So I think the hearings officer clearly notes that there was a concern in that area. On the other hand, the hearings officer does note that this affected area is paying a significant amount of payroll taxes, and that those payroll taxes would then be shifted under the statute. The way that the withdrawal statute works is that the revenue is not lost to TriMet, it goes to the rest of the district. And I think it was his conclusion that there wouldn't be a net benefit overall to the system as a whole if you shifted that tax burden and also the benefits that goes with that, because we also shift the value of the service into the district as well. But it was his conclusion that would not warrant withdrawal. So that is essentially what the hearings officer looked at and what his conclusions were. The next steps in the process after today, we're going to talk a little bit more about today because you've heard from staff and we're on the record, and Mr. Bates is here, who is the chief petitioner of Boring, and he needs an opportunity to be heard. The next steps after today will be for you to, at the board meeting, to listen to any additional testimony That will be in the form of our public forum, which means that people will be limited to the 3-minute time limit. So there's good cause to allow additional time. That will also be on the record. Those comments should be confined to new matters so that we're not listening to the same things that the hearings officer heard and the same things that we're hearing today, but recognizing that there could be additional matters that are important for your consideration. The legal staff will prepare for you 2 items. One is a resolution and one is an ordinance. The reason for that is that the petition is allowed by ordinance and is denied by resolution. So at the board meeting, a member at that time would make a motion. It would either be, I would recommend that it either be to table the resolution until the next meeting, and that is because, I'll try to explain this better than I did last time, that is because there are 2 readings of the ordinance. So in the event at the second reading the ordinance did not pass, you would still have the resolution there. On the other hand, if the board is not inclined to allow the petition, there's no reason for you to not entertain a motion to adopt the resolution, which would then deny the petition. So that's essentially where we are. We absolutely have to finish this process by December 31st. It would take effect if the ordinance passed January of 2013, because that's the way the statute is written. I think that's about the extent of my comments. If you have any questions on that, I can answer them.
Procedural matters, other questions? Thank you.